Good morning, everyone, and welcome to today's webinar session, IP Strategy for Software Technology. We're about to kick things off, and we welcome you to introduce yourself in the chat feature. Let us know where you're tuning in from today. I myself am tuning in here, managing this project for you from Ottawa, Ontario. So let us know where you're coming in from today. We'd be happy to hear it. Okay, so while we await everyone to join us, I'll introduce myself. My name is Rosalind, and I'm the Entrepreneurship Education Coordinator for Invest Ottawa. And with me today is Jeff Leuschner, and Jeff is a partner at Smart Biggar IP Agency. We would like to start off the event by acknowledging that Invest Ottawa, located in Ottawa, is on the unceded and unsurrendered territory of the Anishinaabe Algonquin Nation, whose presence here reaches back to time immemorial. We take this moment to honor their long history of welcoming many great nations to this beautiful territory. Okay, so Invest Ottawa provides various programs such as this one and services to help entrepreneurs, much like yourselves, start and grow all types of businesses. Thanks to the support of many partners shown on your screen, we are able to offer free business consultations and many different webinars for online training and entrepreneurial events, as well as programs for traditional product and service-based businesses and technology-based businesses. We welcome you to check out www.investottawa.ca following the session for more details on these services. Now for a few housekeeping items. It's not a webinar without housekeeping on Zoom, right? So let's just get to it. For a few refresher tips for those who aren't aware, currently all the mics are muted except for mine and Jeff's, and we do that to ensure that you have a great audio experience. So we will ask you to please submit your questions via the Q&A feature located in the bottom of your menu screen here, and we will address as many questions as possible throughout and at the end of the presentation as is necessary. Please note that a copy of the presentation will be distributed following this session, and you will also receive a link which allows you to access this presentation and revisit all the great information that Jeff has covered for a 48-hour period. So please look out for that as well. I will be sending a survey to everyone. We want to know how this went and what your experience was like. So please take the time. I promise you it's not too extensive to respond to that survey and see what we can do for future sessions. Okay, so now, what is the right approach for the intellectual property of a software technology company? Where does IP fit in an anti-IP hacker culture? I'm not going to be the one to tell you. We're going to turn to Jeff, and he's going to be answering those questions. It gives me great pleasure to introduce today's speaker, Jeff Leuschner. Jeff has practiced in the area of IP, intellectual property, for over a decade, with an emphasis on patents. When working with tech companies, Jeff advises on whether to focus patenting activity to best support the company's business objectives, especially in view of other options, such as trade secret protection and defensive publication. His approach is quality over quantity, not just a well-drafted patent, but one that will actually have commercial relevance. Before entering the IP profession, Jeff pursued graduate studies in the field of electrical and computer engineering. And now I understand why I'm not the one that's going to be running this session. I'm going to be turning it over to you, Jeff. Thank you very much. We're happy to have you here today.
Thank you, Rosalind. I'll just share my screen. And I just actually, before I share my screen, I just want to mention to add on to that, Smart Biggar is Canada's largest law firm that specializes in intellectual property law. And we've been doing so for a long time. In fact, we have a flagship office in Ottawa. It's been serving the Ottawa market for over 100 years. So a lot has changed in 100 years for the businesses and for us, of course. But we're still going strong, and we've been happy the last few years to be partnering with Invest Ottawa. We have IP clinics that we run and some master classes, of which this is one of them. And I really thank everyone for attending.
Thank you.
Thank you. That's gonna, from the beginning. Okay, so IP strategy for software technology. A lot of the messages though in this slide deck are going to be applicable even if it's not software technology. It's, you know, a lot of the messages are just kind of a good way to think about IP in relation to your business and business objectives. So just a little intro. You know, when a business owner, like perhaps yourself, is talking with an IP practitioner like me, it's very easy for the conversation to turn to topics that the IP practitioner is most comfortable with. You know, yeah, the IP practitioner, say, might be a patent agent, might think that your business is well served by having a patent. And so it's going to be easy for that patent agent to talk to you about the patenting process, the costs of patenting, the legal requirements to get a patent, etc. And you know, to an extent, that's all good. And if you're to hire that practitioner, they should serve you well. You would find though that they'd be pretty tactical, focused on short and medium-term goals, like how can I get the patent through the patent office and examined, or how can I persuade the judge to see to see the argument my way, etc. That's fine, but sometimes the business owner is asked, well, I know that you do a good job at getting and enforcing those IP rights, but really what does all this have to do with my business? I'm in the business of making a product or a service, delivering something that the market wants, and it being something that is going to be successful for my business too. I'm not in the business of getting patents and suing people, for example. Where is the connection? And so what you want to do when you're working with an IP practitioner, even right from the start to the extent you can, is make sure you're having conversations that are more, we could say, business minded. So focusing less on the nuts and bolts and more on the maybe a little bit more strategic, like how does this IP right link to my business objectives? And by doing that, I think you'll get more value and more understanding out of working with the IP practitioner. So what I'm going to try to do in this slide deck is focus more on the right-hand side of the slide, the more business-minded messages. We're going to talk less about the nuts and bolts of how you get certain IP rights. So I will have a brief discussion of that, but we're going to try to stick to more thinking about IP in the context of your business. So I'd like to start that with a little story to help set some context. This gentleman on the screen, his name was Sir Humphrey Davy. He was a well-educated, well-financed Englishman from the late 1700s, early 1800s. He was quite accomplished. He was knighted. He was a scientist. He was president of the Royal Society in England. As part of his research, he experimented with electrolytic cells, and he actually developed the first electric battery. He then took some copper wires, connected one end of those copper wires to the battery, the other end to a piece of carbon, and that piece of carbon began to glow. That is, he developed essentially the first electric light bulb. That was in 1802, and he called it the electric arc lamp. So he did something that the Oxford English Dictionary defines as invention, something that's never been made before, or the process of creating it. Said another way, from the perspective of a business, he took money and he turned it into technology. I mean, that's kind of what invention is from a business's perspective. You put money into like resources, research and development, and you get some technology that's going to form the underlying basis of your product or service, invention. This gentleman on the right-hand side, his name was Thomas Edison, more recognizable. He took that existing electric lighting technology. He made some improvements to it to make it more commercially viable And then he began selling electric light bulbs under the Edison Electric Lighting Company in the 1870s. So he did something that the Oxford English Dictionary in one definition refers to as innovation, the action of introducing a new product into the market. Said another way, he took technology and he turned it into money. Commercialization, innovation. I mention this because, you know, when we're going to talk about IP rights in the coming slides, we're not talking about certificates for inventors to reward them for, you know, coming up with cool invention. We're not talking about protecting invention. We're talking about a set of tools that, amongst other tools that the business owner will have access to, the IP tools will hopefully help, if they're applied smartly, to help protect the ability of the company to turn their technology into money. And if you can't really see a path to the finish line there, then it doesn't make sense to spend that money on that IP right. So let's zoom out before we talk about the business. Let's talk a bit about Canada. So if we look at the Canadian economy, go back 25 years ago to the late 90s, we hovered around the 8th or 9th largest economy in terms of gross domestic product. We have and had a very large primary sector component. That's the component of the economy related to natural resources like lumber, oil, gas, agriculture, etc. Obviously, we traditionally have been a rich country, mainly because we've been rich in natural resources. We also have a large service sector component. But aside from that, in the kind of industry manufacturing side of things, we had policies in the late 90s that actually focused on mitigating deindustrialization. So factories were beginning to close and the jobs were going down to Mexico where the cost of labor was cheaper. We had tax incentives to help keep those jobs open, those factories open here in Canada. Fast forward to today, we're now the 10th largest economy in terms of GDP, so starting to fall a little bit. We still have that large primary sector component for our natural resources. If you look though on the kind of manufacturing industry side of things, those jobs, those factories that we tried to keep in Canada, they mostly ended up leaving anyway. They went to Mexico. Now they're going to Asia, following the path of cheapest labor. And so now if you look at our policies, they focus very much on research and development or invention. And a good example of this is the Scientific Research and Experimental Development Tax Credit, or SR&ED. And I'm not an expert on that tax credit, and there are some critics. There always are. But you know, the stats show that it's one of the most generous tax credits for research and development in the world. It provides about $4 billion in tax credits or refunds to about 18,000 claimants each year. Quite significant. But it's a tax credit that rewards invention, so coming up with things. So you might be able to get the tax credit in relation to hiring an engineer to do some research and development, but you're not going to get the tax credit to hire a marketing person to help with commercialization, or to hire an IP practitioner to come up with an IP strategy that's going to help provide you with some leverage against other market players. So perhaps because of these policies or our culture, and you know, maybe because we're a lot smaller than our neighbors to the south, put all those things together, some critics, some researchers would say, you know, Canadians have been pretty good at inventing, coming up with things that are useful and can form the basis of products or services that people want, but they're not as strong on the innovation commercialization side of things. And there was certainly a lot of activity and writings around this going back a few years ago, maybe like 4 or 5 years ago. For example, a few years back, the Council of Canadian Academies authored a report about the extent of innovation in Canada. Amongst other things, they observed that patents invented in Canada are increasingly being owned outside the country. That patent outflow is accelerating. So expatriation of IP rights. Anecdotally, is kind of an interesting quote here. Eric Schmidt, the chairman of Alphabet, that's Google's parent company, he had a fireside chat with Justin Trudeau a few years ago in the Google Go North conference. And he thanked Canadians for, quote, inventing all this artificial intelligence stuff because we now use it throughout our entire business. And it's a major driver of our corporate success. So we owe you, right? An example of Canadians developing the technology, but the IP rights and the benefit of those IP rights going to foreign companies. Jim Basile, he's the former co-CEO of BlackBerry. He's co-founder of the Institute for New Economic Thinking. He writes on this, he's observed in the Globe and Mail more than one occasion that over the past 30 years, commercialization of IPs become the primary driver of new wealth. And we, Canada, continue exporting low margin resource and agricultural goods while importing high margin IP. So the good news here is that there's a lot of activity and critique a few years ago in particular. It still continues today. And so the federal government took notice of this. And a few years back, they embarked on what they're calling a national IP strategy. And there's I tell this because there might be some things here that you want to keep an eye on. They've announced and continue to announce a number of programs to try to improve the IP strategy in Canada for businesses. So it's kind of a real collection of different programs. They have these things called innovation superclusters, which is basically taxpayer money being put into particular regions and particular areas of technology, like artificial intelligence center in Montreal. It has SMEs, large companies, academia, collaborating to come up with ideas and hopefully commercialize them. Although, there's questions around who's going to actually hold the IP rights, though, and will they even be pursued? They've introduced some money for IP awareness and education. They have some kind of more obscure programs like this innovation asset collection, which is this relates to patents in the clean tech sector. And recently, in late 2021, they announced some funding for SMEs that are working with the Industrial Research Assistance Program, or IRAP. Companies involved with that program can have some access to money under something called IP Assist, which relates to some IP strategy services. Now, this is great. I commend the government, the Liberal government, for doing this. It's not every federal government that has tried to do something along these lines. That being said, the question has arisen, this is all well and good, but what's the path to the finish line here? I mean, will this kind of collection of somewhat random programs, give us what we want ultimately? I think what we want is to encourage Canadian companies to strategically file and use registered IP assets to give them some sort of commercial leverage, whether it be in the context of a merger or acquisition or in the context of becoming a more dominant market player. Will these collection of programs do that? Some critics would say there seems to be some key missing elements here to get where we want to go. So some elements that have been proposed that have not been adopted include a national first patent program to help with funding for a company's first patent, an innovation box, which is essentially like a lower tax rate on income derived from IP. This is a pretty cold hard incentive to get some commercially valuable IP. If you know that licensing it, for example, you can get a lower tax rate on the income derived from that licensing. The 2022 federal budget, actually, from a month or so ago, they committed to considering this innovation box and seeking views on it, so it could move forward. Another missing element is what they call a commercialization coupon, which is essentially grants for not just doing research, but commercializing that research. So that's kind of what's going on at the national level. Just wanted you to be aware of that. Keep this in your back pocket. There might be something that's of interest to you, maybe some access to funding. I want to leave it there though, and kind of zoom back in again and talk about more on the business level. So IP protection. Why even bother about it, especially for software technology, which, software companies and products, it change so quickly. There's a lot of kind of collaborative development, etc. So a few points here. So let's forget Canada. Maybe we're not even convinced that Canada has a real innovation problem. In any case, people care about their own business. You care about your business. Maybe you or people in your business, they belong to what some might call the anti-IP hacker culture. So, you see this a lot in the software space. Open source software is a perfect example of this. People love the principles of open exchange, collaborative participation. You don't want to put up walls. You want to partner and build something great that you're going to love and that your customer is going to love. And there's nothing inherently wrong about not necessarily being a big fan of IP rights and what maybe you've seen some companies be able to do over the decades with them. And you don't even have to take IP rights that seriously to necessarily still do well. I mean, Shopify traditionally, hasn't been too keen on the pursuit of IP rights, and yet they have obviously done very well for themselves. What I will say is now that they've transitioned from being kind of a startup to being, a competitor to Amazons and Googles of the world, they've had to get more serious about IP and play some catch up. But the point here is that there's nothing wrong with adopting a particular culture for your company, but you still have to play the game. You're still in the market with other market players, and those other market players are going to use IP rights potentially, and in a way that you might not be happy about. And so, how can you think about IP in relation to dealing with that? Because at minimum, you care about not being stopped from using your own IP you've developed to build something great. Maybe though, even you are moving into a new space and you're worried about a second mover advantage from another company that might be bigger than you. You want to stop your competitors from offering that same value proposition that you're offering. So with those points in mind, how should you view and handle your valuable IP that has been developed in your company and that forms the basis of certain products or services? I'm going to talk about that. And I'll keep it pretty simple. There's this talk about like IP strategy. I've used that word several times. It's even in the title of my slide deck. What does IP strategy really even mean? There's different definitions. Let's simplify it. Basically, what I'm talking about is using IP rights to support business objectives that exist independent of those IP rights. Now, there's kind of two business objectives that interface very well with IP. So we're going to focus on those. The first of those is the freedom to operate and innovate. So you want to move into a space and you want to build something great, and you don't want a competitor trying to stop you or putting up some walls. So let me introduce a hypothetical example that we'll come back to a couple of times in this talk. Let's say that you are a startup company in the e-commerce space, and you have an e-commerce platform, like an Etsy or an Amazon or Shopify. You have merchants on that platform. They sell products to customers who come on the platform and purchase those products online. You realize there's a business problem. The business problem is that there's a segment of the population that doesn't really like shopping online because they like more of an in-store experience. At least pre-COVID, my wife was like this. She liked to go into the store and hold the product in her hands and see the size of it, and then walk up to the cash and check out. She was not big on buying online. You have decided as a business that you want to try to bring virtual reality to e-commerce, because then customers can have a VR experience where they're effectively walking through a store, picking up a product, holding it in their hand, looking at it, going to a cash and checking out. it's an emerging space. It's a little bit ahead of its time, but it's it could be here before we know it. You want to be a kind of a first mover in that space. You figure this is going to be good for your platform. More customers will come, buy more products for your merchants. Your merchants are going to be happier. You're going to be happier. You're going to make more money. So you want to move into the space. The challenge is, though, that you're not alone. Shopify is interested in moving into this space. I think they're focused a little more on AR right now, not VR, but they're moving in that space. Amazon is interested in moving into that space. Walmart is interested in moving in that space. Let's pick on Walmart because we have a conflict at our firm, so we can't represent them. They're not our client. But they're a very sophisticated company. They have a lot of IP rights. If Walmart sees you moving into this space and you're building something that's getting traction in the market, that the market, it turns out the market wants this and it's growing and you're having success. Well, Walmart, might want to slow you down or stop you, especially if they kind of want to play catch up. They might look at their own patents in that area and say, yeah, you can't do that. You can't go there. They might somehow hinder you using their own IP rights. How can you help protect against that? So we'll talk about that.
And you're moving into that, Jeff, sorry
Yeah,
to interrupt. There's actually a question that came through that
please.
kind of interweaves into this. Can software be patented or is it likely to be copywritten? So, you have sort of kind of touched upon that, but I wanted to bring that forward.
Yeah, that's fair. I'm going to talk about that in a little more detail in some coming slides. But what I will say is that software per se cannot be patented, but the function that software does can potentially be patented if it's patent eligible. So if you can spin it, or I don't want to say spin it, if you can frame it and explain it as an improvement to functionality of a computer or some sort of technology, you're not going to patent the software per se, but you're going to patent the thing that it does, which effectively means if anybody writes software code in any language to do that same thing, then they would be infringing the patent. Okay,
looking forward to hearing more. Thank you.
Oh, you're welcome. So, the other objective here is that you might actually want to get some commercial exclusivity. So Walmart is, might also want to move into that space, and you maybe want to stop them. Like Walmart doesn't really care about you, but they care about your merchants, having them move over to Walmart's platform. So how can you use IP rights to kind of stop that second mover advantage that sometimes bigger companies have? So with those in mind, we're going to talk about kind of 5 tools, IP tools that are going to help. And we're going to talk about each one. But let me just introduce them. I'm going to talk about patents. What is a patent? How could it help? Where does it fit? Designs, or they're called design patents or industrial designs. Sometimes they're called that also. We'll explain what they are. Copyright protection, rely on copyright protection for the software code. When's that appropriate? Trade secret protection, and an action referred to as defensive publication. So I'll just keep one slide on each of these to explain them. Then we'll go back to how they can map and link to those business objectives. I should mention trademarks, your brand. It's obviously very important for a company. We're not discussing it here. In fact, we have a whole separate class just on your brand and trademarks. We're just focusing more kind of on the technology itself. So a patent, what is a patent? What can be patented? Well, a patent is essentially a government granted right that protects an invention that has to meet certain criteria. The invention has to be new, not obvious, and useful. There's certain things that you cannot patent. So you can't patent like an abstract business idea, an equation per se, an algorithm per se, or even software per se. But what you can patent, and that kind of interfaces with those things you can't patent, is improvements to computer functionality or to technology. So kind of going back to the answer to the question from the last slide, it's like you can't protect the software code directly, but if it's performing some sort of function that you can explain as being an improvement to computer functionality, then you have something there. Now, a patent can be very valuable because if you have a patent on an underlying technology that forms the basis of a product or a service, you can prevent others from implementing that underlying technology or selling it or manufacturing it or whatever for 20 years from the filing date of your patent application, which is a long time, especially in the software space. So that can effectively, in some cases, provide you with a sort of monopoly in the market, which is very valuable. Now, when you think of patents, it's easy to think of like the mad scientist in the lab, or in the software context, you know, your data scientist who's come up with this really great training algorithm or analytics or machine learning of some sort or search algorithm. The truth is, though, that the patents that are typically most valuable to a business are the ones that have enough inventiveness to squeak by, but protect the technical underpinnings of the user experience, what the user really wants, UX. And a perfect example of this is the Amazon's patent for one-click internet shopping. So, you know, this is going back early 90s, or sorry, mid 90s, late 90s. Just everyone probably knows what this is, but just to make sure, when the first time you go to Amazon, you buy something, you have to provide all your billing information, shipping information, and details, payment card details, etc. Next time you go back, you can just click a button on the screen saying buy now, and that causes a whole order fulfillment process to initiate. Now, Amazon did not patent the idea of one-click internet shopping. You can't do that. They didn't patent a look of a button on a screen, or like clicking a button on the screen for one click. You can't really do that either. What they patented with the broad technical underpinnings at the platform level that would be required for any business to implement one click. So receiving the HTTP request from the user device, grabbing a cookie out of it that has the user's ID in it, sending that cookie or that user ID to a server that has the previously stored information, sending that to an order fulfillment server, like without going back to the user device. You know, steps like that. It's like they're technical, but they sit just underneath the user interface. And they were able to protect this in a way such that anybody who implemented one-click internet shopping would have to implement it this way and would infringe this patent. Now, the engineers at Amazon are smart. They come up with a lot of cool things like cryptography algorithms, et cetera, et cetera. From a technical perspective, this was like a very boring invention. You know, it's not that cool. But here's the thing, it protected the underpinnings of what the market wanted. So customers love this one-click feature because they don't have to re-enter their information. That's inconvenient. Businesses love this one-click because it promotes impulse buying. They even have a problem named after this, the abandoned cart problem. It's like, you know, you add a bunch of stuff to your cart online and then you go to check out and you're like, by then your brain's kicked in. You're like, yeah, I don't really need, you know, that thing. I'm just going to wait. The one-click button, merchants love it because it's like the impulse. You just click the button and then it's bought. Yes, you could reverse it, get a refund, stop the shipping, but you know, that's a lot of work. Usually you don't. So the market really wanted this. Amazon was able to protect the technical underpinnings of it so that no one else except Amazon could provide it. Of all the patents that Amazon has gotten and has since gotten since this patent expired, this one-click patent was by far the most valuable. Rumor has it that Apple paid Amazon $1 billion to be able to use this feature and implement it in iTunes. So the take-home point here is that when you're thinking about patent protection in relation to your business, don't get hung up on like the cool tech that your engineers have come up with. think about what's the user experience that the market you think is going to really want, and can you somehow protect the technical underpinnings of it in a patent to protect indirectly that user experience. The other type of IP right is design patents, also called industrial designs. And this is like a patent, except instead of focusing on like functionality, it focuses on how things look, ornamental features. Because of that, they're not typically as valuable because it's easy to design around things by just having something do the same thing but look differently. That being said, there are some situations in the computer software space where design patents have shown to have value. For example, Apple was able to get a design patent on the idea of having like a screen with a grid of icons, each icon being an app with kind of like a slightly curved edges. That's basically become like the de facto standard, what like customers want, whether you get like an Android or an iPhone. You're used to seeing a grid of icons, and the icons kind of have a certain look. So that design patent turned out to be very valuable for them. They also got some design patents around like the shape of a mobile device, like having the button on the bottom of the screen, that sort of thing. The other IP right that we're going to consider is copyright protection. Now, you think of copyright when you think of authors, like writing a book or writing a song, those are automatically subject to copyright protection. But so is software code. It's copyright protected. So there might be certain situations where you're going to rely on that and maybe just leave it at that. Then there's an action. It's not really an IP right per se, but it relates to IP. It's called defensive publication. In relation to some IP that you've developed, you can purposely put it in the public domain. And by doing that, it limits the ability of others, market players, to be able to independently develop that and get some sort of protection like a patent on it and stop you. So you might be giving up commercial exclusivity because you're kind of putting it in the public domain, but you're also stopping others from being able to stop you from doing it. This trade secret protection is another IP right to consider. In this one, you're not relying on any sort of government granted right. You're just keeping your IP secret. And keeping something secret doesn't mean that you decide not to publish it. It means that you actually consider it to be a trade secret and you take steps that show it's a trade secret. And this is important to, one, keep it secret, but also if you ever had a rogue employee take it away and you had to file some action in court against them, you need to show that it was clear that this was considered in the company to be a trade secret, not just information that's fine for anyone to take and use and take with them to another company. So this means you decide for a particular trade secret, that's what it is, and you're going to take steps to keep it secret, like virtually or physically partition your software code related to it, limit access to it, have company protocols in place related to it and educate employees on those protocols, and have confidentiality agreements where necessary. So patents, design patents, copyright, trade secret, defensive publication, the 5 tools we're going to talk about. So let's kind of start pulling this together. You have IP that you've developed, as part of your product or service. And how do you handle that in terms of like considering it in relation to business objectives, mapping it to potential IP rights or actions to take? This slide's going to help provide some guidance on that. So on the bottom of the slide, we have an axis that's freedom to operate and innovate. Vertical axis, we have commercial exclusivity. I'm going to map those IP rights to this grid, and then we'll talk about when it makes sense to pursue one right compared to another. Let's think about patents. So remember, the patent is, protects your underlying technology. You can get it for something you can characterize as an improvement to technology or computer functionality. I would put it high in terms of its value of providing commercial exclusivity for what it protects. because if you have a patent protecting that technology, you can stop your competitors from making, using, selling, implementing it for 20 years from the filing date of the application. It's a long time. Provides you with some commercial exclusivity in the market. I also put it high relatively on its freedom to operate and innovate value because of its defensive value. So think about it this way. Let's say, go back to our hypothetical example, you want to bring virtual reality to e-commerce. So you start to move into that space and you start to research, design, code the pillars of what you think that solution needs to look like, the pillars of what the market would require for any implementation of virtual reality in e-commerce. And they might be things like, you need a way for like the merchants to be able to create 3D models of their products and the different variations that they can switch between, a way for like the user to, interact with those products, etc. If you then get patents on those basic pillars of the technological solution, you're essentially controlling access to that technology. Now, any other company who wants to move into that space will infringe those fundamental patents because they fundamentally need those same pillars in their solution that they offer. So now this means that you don't have to be the bad guy, but you can if someone else is giving you a hard time. So you're building in that space and Walmart comes along and they're thinking of trying to say, stop you. Maybe they have a patent right that they want to assert against you. They're sophisticated. They're going to see your patents in that space. They're going to realize that if you assert them, it could hurt them, and they're going to be more cautious. Maybe even you can use it as leverage to form the basis of a partnership with that other company, like with Walmart, so that you can build something great together. So there is some defensive freedom to operate value with a patent. Now, that sounds good. Why don't we just get a patent for everything, right? It's like high commercial exclusivity, high freedom to operate. The problem is that patents are expensive, tens of thousands of dollars for a single patent on a handful of countries. So you want to be very discerning about whether to pursue patent protection. It's going to cost a lot of money. So I have some criteria that you want to apply. If you meet all the criteria, then it's potentially a good candidate for patent protection. So you have some particular IP right, that you've developed. You want to ask yourself, okay, will this, if I get a patent on it, will it protect a valuable user experience? That's important because if it doesn't, then your competitor's not going to care about that patent. They'll just do something different. Will it have a long life cycle? This is important in the software space because your features and your competitors' features are going to change quite quickly. Would it be detectable if someone were infringing this patent? If you can't even tell if someone's doing it, it's going to be hidden on some server in China, then good luck. Can you patent it in a way that's hard to design around? If you have something that meets all that criteria, then that's a pretty good candidate for patent protection. If you don't, then that's okay. Just move on. Maybe you can map it to another IP right that we're going to talk about. Now think of Amazon's one-click internet shopping patent. It met this criteria. It protected the valuable user experience, one click. It had a long life cycle. Software changes quickly, but that one-click internet shopping is going to be here forever. It's easy to detect because it sits just underneath the user interface. You can tell if someone's implementing one click. And they were able to patent it in a way that's hard to design around. So Amazon met all that criteria. It was a good patent for them. And it proved to be a good patent. What are your other options? Trade secret protection. This could work for certain types of IP that you have at your company. I wouldn't put it as high in terms of commercial exclusivity and freedom to operate value, because if somebody independently develops that same feature and or tries to get some protection on it, they can potentially stop you, or they can compete with you and you can't necessarily stop them. but there is some value there, particularly if it's the right thing. Trade secret protection works for things that are hidden and that are hard to reverse engineer. Think of like Google's search algorithm. It's like you put in a search term, you get back the search result. You don't really know how they're doing it. It's hidden on some server. You can't really reverse engineer it. That's a good, they keep that as a trade secret. It's a good trade secret. Trade secrets are also good for things that aren't patent eligible. Can't get a patent on everything. If it's not some sort of improvement to technology, it's probably not patent eligible. The thing is, though, trade secrets, they often protect like the crown jewels of the company. Think about some of the things that's most important to a software company. One, for a lot of companies, the data that they've collected. Can't get a patent on the data, but having that data, is giving you a big leg up. Well, keep that data secret. The know-how of your employees. These are big things that you can keep as trade secret protection. Another action that we talked about is defensive publication. Remember, this is like putting it in the public domain on purpose. No commercial exclusivity value, you put it in the public domain, but it has some freedom to operate, innovate value, because if it's in the public domain, another person or another company cannot get some sort of IP right on it and stop you from doing it because it's in the public domain. This might work well for features that you've developed where it doesn't make sense or you can't get patent protection. It doesn't make sense or you can't rely on trade secret protection. But you want to help ensure some freedom to operate or innovate value. Design patents. Remember, these are like patents, but the ornamental features, how things look. Again, if you can get the right one, they have the same value in many ways as a regular patent. But generally speaking, they're more limited because you're just, thinking of ornamental features like at the user interface. One advantage is they're not as much money to pursue. Finally, copyright protection. There are instances where it might make sense just to rely on copyright protection for your software code and just leave it at that. Copyright protection has low commercial exclusivity value because a competitor could do the same thing just using different code. Its freedom to operate, innovate value is really a function of whether it's public or not. But it's just a good kind of fallback for software implementations that are not overly commercially valuable. So I would say this is like a main slide in my deck. You have your 5 IP tools. You can do a bit of audit for your own IP. Like go through your company or while you're thinking about your features that you're designing and say, okay, what of these IP rights, which one kind of maps to which tools to achieve which goals. So I have a couple more slides before we finish off that I want to focus just a little bit more on patents because patents are often of interest to people. Let's think about patenting in the software space. Now it's very general, but I often think of software as having 3 different layers. At the outer layer, you have the user interface. Now, the user interface is really important for your brand, and for usability. You want it to look good. You want it to provide the functions that make it easy for the user to interact with your system. The problem, though, from a patent perspective is that, it's often a short life cycle. User interfaces change a lot and quickly. They're easy to design around, just kind of do the same thing with a different looking interface. Maybe there's some room here for like a design patent, based on how something's laid out or looked or an animated icon. But generally speaking, not good candidates for patent protection. On the flip side of software, in many pieces of software, not all, but some, you have at the core some sort of algorithm that's really forming the basis of the whole service. This might be like a search algorithm or some sort of analytics, some sort of machine learning, etc. Now, this often is where there's the most invention. It's kind of the coolest part, the thing that's the engine that's running the whole system. But think of like your typical software as a service. The code is not being, the algorithm is not being given to the customer. It's being hosted on a server somewhere, like in the cloud. Detectability is going to be hard. You don't really know how that algorithm works, or if someone were to infringe that. Not really a good candidate for patent protection for those reasons. Trade secret protection is often a good candidate. So this leaves us with the kind of the non-sexy in between, what I call the platform, including the platform features that support the user experience. And this is where you could find potentially some good candidates for patent protection, because this is kind of where it just sits right below the user interface, some software, hardware interaction. Detectability is still good because it's close to the user interface. You can maybe protect the features that protect the user experience indirectly. And Amazon one-click, is again the perfect example of this. Amazon didn't patent the look of the button on the screen, the user interface. They didn't patent some like poor algorithm at the bottom of the service, like this, there isn't one. They patented those broad platform features that are required for anyone to implement the same service and software. Like I said, the receiving the HTTP request, pulling out the cookie, sending it to a server to pull like previously stored information, etc. In terms of your patenting strategy, it's common for a company to kind of start off with what I'll call product-driven strategy. So when you're thinking about potential patents related to your product or service, you want to ask yourself the business questions like, what does the customer love about this product or service? What would be its design cycle? Would that feature be detectable? Would it be hard to design around? What is my value proposition over my competitors? Those are the kind of the questions that will lead to what might make sense to patent. And you can let the patent agent kind of help you with the more technical questions of, is this new enough to get a patent, or is it patent eligible? Then smart companies will also, who pursue patents, will also look into a technology-driven patenting strategy. Forget about your specific product at hand, but kind of look to where you're going and the market's going. What are the competitors doing? Where's the market going? What can we like kind of capture in that area and patent? And then we kind of keep those patents alive. And if the market goes in that direction, then we're good. If it doesn't, then we get rid of those patents by not paying maintenance fees on them. Now, this is only anecdotal, but in terms of funding, private equity VC investors, they're happy to have those product-driven patents, focused patents that support on kind of protecting where your revenue is going to come. More strategic investors would be interested in the broader speculative patents. And if you're public, or if you're going public, a larger portfolio with a mix of both types would be good. Okay, before I conclude, just a quick case study to pull together a few of these ideas. It's hypothetical. It's not a client of mine. In fact, it's a variation of a case study that I read myself. So I don't claim any rights here, but I think it's a good one. A large percentage of fruits and vegetables, they're wasted each year due to spoilage during shipping. This is a business problem. It's lost profit by produce sellers. So this startup company, Table Fresh, they're dedicated to solving this problem using technology, using artificial intelligence in particular. Essentially, how it works is that as produce moves along a conveyor, the company's technology senses 5 different parameters of each piece of produce, and then uses a uniquely trained AI model to predict the shelf life of that piece of produce with 96% accuracy. Then pieces of produce with longer shelf lives are automatically sorted for long distance shipping and vice versa. Now, this chief technology officer, she invented the company's AI training model. It was quite a feat. The chief scientist, he invented the underlying idea of estimating shelf life using the model specifically based on these 5 parameters: moisture, bacteria, mold, oxidation, and physical damage. Okay, what do you patent? Well, option 1, we could try to patent, lock down that AI training model. You know, there's a lot of invention put into that. You know, it's that training, you know, causes you to be able to have a model that works well in practice. Well, here's the problem. You know, how would TableFresh even know if someone was infringing that patent, like a competitor? How often would training even occur? Like, how often would the patent be infringed? And, you know, couldn't you maybe tweak the training to get like a different, you know, a slightly different approach with the same result? So, you know, that's probably a better trade secret, not a patent. Okay, so what about option 2? The idea of estimating shelf life based on that specific combination of physical parameters: moisture, bacteria, mold, oxidation, and physical damage. You know, it was discovered, you know, that specific combination has quite an advantage. Well, now you're doing better in terms of potential patent. I think this could potentially be competitor blocking, but, you know, it's maybe not as locking down as much as we want, because the industry might be able to bypass that patent by eliminating or substituting one of the sense parameters. I don't really think you're fully controlling, you know, the access to anyone going into this space and doing the same thing. So how can we do better here? Well, let's step back from the technical nuances and consider the minimum commercially viable solution. Could we protect a conveyor system that senses physical parameters of each piece of produce, determines an indicator related to shelf life, and sorts each piece of produce based on that indicator? Now, this is good if you could get protection on that, because basically it's capturing the minimum that every competitor would have to do the same thing, which gives you a strong commercial exclusivity and freedom to operate position. It's not limited to like AI or any of those details. Maybe this is too broad. Maybe you can't get a patent this broadly, but you're not going to find out unless you turn your mind to it first and discuss it, you know, with the agent, or the agent discussing it with TableFresh, rather than just getting hung up on the cool tech of the AI training model or the parameters themselves. So in conclusion, there's just more business sense to controlling access to the technology in the space you're in when you can, and you use enforceable IP rights to help achieve that. Doesn't mean you have to be the bad guy. And even, you know, collaborative things like open source is only successful because, remember, IP rights are being used to enforce behavior. Open source is enforced through copyright licenses, you know, to prevent bad players from modifying the code and not sharing it with others. At minimum, you should care about freedom to operate, which itself is a strong incentive for caring about IP. So if that IP is valuable, then crystallize it and leverage it where you can. And that's my deck. It's about an hour, I see. So I am happy now to take any questions before we wrap up.
All right. First of all, fantastic session. Thank you so much, Jeff. I was actually ruminating on some of the points, and I loved how the case study brought it all together. And I welcome everybody that's joined us today. And again, thank you to the attendees to submit your questions now. We did receive a couple, one of which I could answer, and the answer to that was yes, the deck will be provided after the session. But if you have any questions, this was a really rich masterclass discussion, and I think that it's fair to say a lot of people pay good money for this type of content. So I really hope that you've consumed it, made your notes. In the chat feature as well, I have provided a blog post that Jeff has written in terms of when do I patent my software-based product or service. I invite you to check that out as well. So let's just see if we have any questions coming in. All right. First question, well, second technically, can you explain again why open source is successful due to copyrights being enforced as per the last slide. Thank you for that question.
Yeah, of course. So first of all, I'm not an expert on open source, and that there's lots of different types, but in general, open source software code is governed by a license, like pretty much all software code. So when you use it, you have to abide by the terms of a license, and that license is essentially a license that relates to the IP. You know, the IP in that case is the open source software code. And these different licenses, they're basically referred to as copyright licenses. They place limitations on what you can and can't do with that open source code. So one common one, as I understand, and again, I'm not an expert, is that if you modify that open source code, you make the modified version available. There are some other ones that relate to, like, you know, you can't patent what's in this open source code, etc. So if you didn't have these license agreements that essentially you agree by when you use this open source code, then you're going to have market players who are going to, who could, not necessarily, but they could be a little bit of a bad actor. So an example might be, they take that open source code, they modify it to make it better, and that modification, you know, provides some sort of commercial advantage to them. And then they don't share that, they get like a patent on it. You know, again, it kind of goes down to the specifics, and I'm not an expert, but the licenses themselves place restrictions to allow for the benefits of open source to continue, the idea of collaboration and sharing. You know, you can't put up walls because the licenses stop you from doing that. So, you know, it's an idea. The idea is that, you know, you're not using the IP right to be the bad guy, you're using it to stop others who might do things that are different from what you think the goals should be for that IP. And then similarly, you know, in the context of your business, you might not be interested in like getting a patent and suing somebody. But if you have a patent, you know, on that technology that could prevent others from moving in that area, then, you know, that gives you a strong position for collaborating with others, saying, you know, look, I kind of locked down this area. We could stop others if we had to. It allows you to be a bit of a gatekeeper, and it's essentially, you know, it's better to have that power than to not have that power.
Thank you very much for that response, Jeff. And I'm going to take in the second question, which is, can I patent a collection of certain services on an app or website? Yeah, so
that's a little tricky without knowing the details, but I would think perhaps not. It depends. What, you know, when you're just thinking about apps, it's and services that you provide via apps, whether it's a collection of services or not, it you know, that patents don't always play a big role in those sorts of those sorts of endeavors. Now, it doesn't mean that you can't get patent protection necessarily, but you really have to ask yourself, is there some sort of kind of underlying technology improvement at the platform level? You know, if you're just basically like presenting information, you know, collecting information and presenting it, that sort of thing, in the most abstract sense of, you know, characterizing it, it's going to be harder. If you're doing some sort of kind of machine-human interaction, then, you know, maybe there's something that's notable, then maybe there's something interesting there. So think of like the one click. You know, you could have Amazon has an app, and they have one click in that app, but you know, the thing that's interesting there is like there's a feature being provided kind of at the platform level that at least at the time. I mean, it's all, the inventions come along, internet's come a long way, but at the time it was like, yeah, the user, you know, submits the HTTP request, and then we pull the cookie out of it, get the user ID, do some stuff in the background, etc. And then you don't need to go back to the user. So it's kind of like a little bit of a machine user interaction there, and the machine, i.e. the computer, doing some interesting stuff in the background at the platform level. So if you can if you have something like that going on, then maybe. But if it's just like a lot of apps are, where it's just, collecting data, presenting that data, then maybe there's not a lot of room there for a patent.
Okay, thank you for that.
Yeah.
Here's another great question. So if we are using outsourced development with IP ownership provision included in contract along with NDA, do we need anything further to look at patents?
Can you repeat that question? I just got to digest that.
For sure, for sure. If we are using outsourced development with IP ownership provision included in contract along with NDA, do we need anything further to look at patents?
So I take it in that scenario, just to make sure I understood correctly, that you're a company and you have outsourced a contractor to do some development for you. And as part of that outsourcing, you have an agreement, contract agreement, that protects IP rights and ownership. That's a good thing in and of itself. Now, whether, but if it's something that's being developed that's still potentially, say, patent eligible, it makes sense to patent, then it's still might make sense for you as a business to pursue that patent right, because you don't have to worry about the contractor that you asked to develop it, but you do have to worry about the other market players out there and trying to get commercial exclusivity on that feature. What I will say though is that for for companies that have constrained resources and or are startups or still very small, a lot of times you can be smartest by just making sure you've kind of locked down those sort of clauses that you talk about in the contract for like contractors developing stuff for you, because there are lots of instances where there's not a clear chain of who owns the IP rights for what has been developed. And I don't remember all the details, but like Snapchat, for example, when they were a very small company, not yet successful, they had like some co-op student they hired that did some like coding for them. And then, then that co-op student left and went on, did other stuff. And then Snapchat subsequently becomes very, very popular and is, bringing in revenue. They have a good market valuation. Suddenly this co-op student comes out of the woodwork and says, hey, like I developed that code and like I own that. And Snapchat ended up settling to make that problem go away. And I think if I recall, based on like their Security Exchange Commission filings, it was something like $10 million or something they paid this guy. So it's like, in a way, like just making sure those contracts, with your employees and with these third parties relating to IP right ownership, making sure that they're present and good, might end up actually being better for you in terms of a spend of your limited resources than saying, oh, I'll get a patent for this.
Honestly, this is just reiterating the importance of doing due diligence in all of these aspects. And again, I'm learning a lot along with the attendees. And there's another question here: how much detail will be disclosed in a patent that makes it defensible and yet able to be registered by the patent office? And the example would be Amazon's one-click buy.
Yeah, so you need enough detail disclosed so that any person skilled in the area, they don't have to be the inventor, but they're not just someone off the street, someone who's skilled in that area, like in software programming, for example. When reading that, they would be able to go and implement it. Now, they couldn't if you have a patent on it, but that's the level of detail. So, if you think of Amazon one-click, you might explain like receiving the HTTP request, getting the cookie out of it, etc. You know, you don't have to explain how you look, you know, how you read an HTTP request. You know, because like a person who programs software or in that area in the internet, like they would know these basic things. But at the same time, you can't just not mention how it's done. You know, you can't just say, oh, like they click it and then it pulls information and then the order goes through. You know, like that would be like a 1-paragraph description. So you have to, you know, you have to kind of find that middle ground, and it's not even the rule of thumb, it's the requirement that it has to be explained in a level of detail that a skilled person in that area could read it and go off and implement it.
Great. Okay, thank you. Selfishly, I do have a question, and I hope it speaks to what's on a lot of the minds of our attendees today. We covered what was, you know, in terms of IP, and you referenced about 100 years of history there, and what is and what's going on. What's happening in terms of what will be that you would pass on to everyone in attendance today if you were to identify a trend that you really see becoming significant moving forward in the future? What would that be?
You mean in terms of like different areas of development that where they're like patents being pursued, et cetera?
Yes. Yeah.
Well, I can tell you there's certain areas of technology where they're big in the patents and there's a lot of activity there. There's others where there's still a lot of activity and stuff going on where they're not necessarily as big in the patents. So a big area of research right now where there's also a lot of patenting going on, and is going to continue to be for the next several decades, is in wireless communication. You know, this 6G, so you might have heard of like the 5G networks, the 5th generation. It's like, well, the 6th generation is what a lot of big companies out there like Qualcomm, Huawei, Ericsson, Nokia, etc. They're all kind of doing some cutting edge research to try to move in that direction. And in particular, this area called like Internet of Things, where it's like everything is going to be like have sensors on it that's going to be connected to the internet. And, you know, they're all going to talk, and you're going to have autonomous vehicles driving around where like, you know, there's sensors like sensing things and communicating with other vehicles to make sure like there's no accidents. That is a significant technology lift in terms of like all the protocols that have to be developed, the sensor technology, et cetera. There's a ton of research going into that by many companies, and there's a lot of patenting in that area. So that's one area. Another area is, not surprisingly, machine learning, artificial intelligence. You know, I did a machine learning patent in 2010 was the first time I ever did a patent that related to machine learning. And he didn't even call it machine learning back then. Machine learning in 2010 meant like Terminator or something. It was like that. Now, like machine learning is like, you know, seen as this like good thing. There's a lot of development in applications of machine learning algorithms to specific scenarios. And, you know, there's patenting going on in that area. And that area in a way is kind of a little scarier. It's like, who knows, you know, where we're going to be in 50 years. We really have to have some regulations around that. But I would say those are two big areas that kind of relate to electrical computer space, software computers that there's a lot of development in. There's other stuff too, of course, but they jump out.
I'm probably going to be dating myself, but I was thinking back to the times of the Jetsons, right? When I was a kid, I was like, that'll never happen. Star Trek, you know, the holodeck and all that, and it's happening. So when you talked about 6G, I was like, I don't know if I'm ready, but that's where it's going, right?
Yeah, I don't know if we're ready as a society, but once you open the door and walk through it, you can't walk back out.
Exactly. I did receive another question, and this one I can answer due to somebody having some tech issues. Yes, the presentation deck and a 48-hour access to the recording will be available. I myself intend to listen to it myself again, and I was trying to take as many notes as possible. I hope everyone here captured as many points that were valuable to them as well. So, I have a question for the attendees today. And one of the questions that I have is this working for you? Do you prefer a webinar? Or are you more of an in-person person? So if you can just take a quick moment and respond to the poll questions that has launched on the screen. We would love to know as we're moving into this slow, trepidatious space of hybrid, potentially fully in person, what that would look like. While everyone is making their responses known, Jeff, I would like to thank you again for this valuable time that you've made to present us with this really great masterclass. We do look forward to having you back again. And I would like to also thank all the attendees for coming out. Your time is an investment in your business's growth and in innovation itself. So please receive our gratitude for making time to come out today. And you will be receiving all the information that I have referenced before the end of the day today. So again, thank you, Jeff. Thank you everyone for coming out, and we'll see you again for the next webinar.
Thank you, everyone. Take care.
Take care. Bye-bye.